All right, so to get lawyers weigh in on this matter, let's head to Abuja. Markwe?
Well, thank you, Chamberlain. I'm now being joined by Chukwuma Machukwume, who is a senior advocate of Nigeria and former Attorney General of Imo State. We also have with us in the studio Mr. Tajuddin Ladoja. He's a legal practitioner and he's with us in our Abuja studios. Gentlemen, you're welcome to Sunrise Daily.
Thank you.
Should I say learned gentlemen?
Oh, thank you.
You're welcome to Sunrise Daily. Well, you have seen and you have monitored this matter, I want to believe, since it first of all broke out in January this year. And today is the 19th of April, just about 3 months when this petition was written, and we have seen a judgment now passed on the former Chief Justice of Nigeria. What are your immediate impressions of how this matter has been conducted? Let me start with you, Leonard.
My impression is what it should have been. In the first place, there's this issue of when you talk about programming a computer, check it in, check it out. I'm not surprised the way the conviction is done, because from the word go, I think it had been programmed that way. It's like when you're talking about the drone. You set up the drone. It moves. No other way until it hits the target. The target was just hit yesterday. So I'm not surprised.
Okay, no surprises for you. What about you, Ms. Ladoja?
Thank you so much for having me, and good morning, viewers at home. To me, I would say that in all trials, either criminal or civil, it is programmed. From the point of initiation of criminal charges, the point of hearing of witnesses from both sides of the divide, and ultimately the counsel will address the court, and the last stage will be judgment. So to me, I do not think, and I don't want to subscribe to the view or the opinion that it was staged. It's a normal setting for all trials in our adjudicatory system of justice.
Because I was just about to ask you to expatiate a bit more on what you meant by programmed. I mean, you say you slot something in and then it comes out with
the way you slot it in.
With an outcome.
Yes.
What does that mean? What are you trying to say very clearly?
First, the charge you're talking about was set when he was appointed in 2006, and then in 2011 he didn't do this, he didn't do all that. Why was that charge warehoused till now? Why was that offense that said to have been committed in 2006 warehoused till 2019? Why? 2, how about the provisions of the Constitution? Was the CCT supposed to try a sitting judge? Is he supposed to do that? 3, when there are court orders, our judicial system we have an introspection of what our judicial system is. When there's a court order, good or bad, until it is set aside, it must be obeyed. There were 4 court orders. 4 court orders from different arms of the High Court that gave an order that the CCT tribunal should no longer sit on that matter. Why was it disobeyed?
You said High Court.
Yes.
You heard,
the Federal High Court gave an order.
No, just a moment. What we heard is that they are both courts of coordinate jurisdiction, and this was a ruling of the Supreme Court.
Whether they are court of coordinate jurisdiction or not,
yes.
Once there's a court order, it must be obeyed. You're not going to sit on appeal against your own court of coordinate jurisdiction. Once there's a court order, it is for you to obey it. Otherwise, you go on appeal against it until it is set aside. Those 4 court orders have not been set aside up to now.
Is that
yes.
correct?
And then more. And then more.
Just a moment. Let him quickly.
That is absolutely not correct. The Code of Conduct Tribunal has a specific mandate given to it by the Constitution of the Federal Republic of Nigeria. The mandate is exclusive to the Code of Conduct Tribunal and that is trial of whoever has infracted or infringed upon the code of conduct listed out in the Constitution. Those courts, Federal High Court, and I think one other court in Abuja, who gave the order, those orders are void ab initio because the CCT and the Federal High Court are courts of coordinate jurisdiction when it comes to matter of code of conduct infraction. So I do not expect the Code of Conduct Tribunal to obey an order given by a court of coordinate jurisdiction. For example, a Federal High Court in Abuja, for example, is given an order that a Federal High Court in Lagos should not sit over a matter. It will not be obeyed. Because the subject matter, we have to watch and make it abundantly clear. The subject matter before the Code of Conduct Tribunal was infraction of Code of Conduct.
Do you agree with him? Because what you have said...
The question now is this.
Just a moment. You first of all said that even if there were courts of coordinate jurisdiction, he had to obey, or the CCT chairman had to obey that particular judgment, or is it a ruling or order before, you know, he could have proceeded? Is that what you're saying?
Even if a Supreme Court is sitting on a matter and there's a comment from a High Court, Supreme Court will have to give deference to that comment from the High Court.
Yeah, but hold on, sir.
So,
let me just,
it does not matter.
now, let me ask. He gave this example of, you know, 2 federal high courts. You know, because it might confuse our viewers when you say the Supreme Court listening to a federal high court. But if 2 federal high courts are sitting on a particular matter and one of the high courts says, don't sit on this matter, or gives a ruling that, to the effect, should see one of the other high court not sitting on a matter, are you saying that the first or the second high court will have to suspend sitting?
The most important thing is that there's a court order. The most important thing is that there's a court order. And that court order, it doesn't matter whether it is coordinate jurisdiction or not. The most important thing is that there's a court order. Because the anarchy you are going to create is this. Where you now sit down and then start selecting which of them to obey and which of not to obey. Then you are going to create a scenario where people can now disobey court order and then go on to do whatever they want to do. Once there's a court order,
it must be vacated.
It must be until it is vacated. That's the judgment of the Supreme Court. Once there's a court order, stupid or not, within jurisdiction or not, you must have to obey it until it is set aside by higher courts. So it is not for you to sit down in your bedroom and then start selecting which to obey or not. Otherwise, we create an anarchy that will leave the society in the worst state. What we have witnessed is we have introduced anarchy in our judicial system, where any person can sit down and select which of them to obey. Secondly, let us take it higher, more. After the court order was disobeyed, NJC sat and said, CC chairman, submit yourself to Federal Judicial Service Commission as per what you did. What did he say? No, I'm not going to do that. I'm answerable to the president. Where are we? 2, there is a motion brought to you that you don't have jurisdiction. Rule on it. If there is an issue of jurisdiction comes to you, what you first of all have to do was to rule on it, either absorb yourself, either assume jurisdiction or not. What was done? It was deferred. And then finally, the question of recluse yourself.
Or bias.
Of bias. The question of recluse yourself. Where has it been done that you are accused of bias, and then you still comfortably sit on it, sit on the proceeding?
Well, in an instance where, so let me ask you this: in an instance where the CCT chairman is accused of bias, and we know that usually there will be 3 members of a panel in the Code of Conduct Tribunal. what should happen in that instance? Are there other people who can sit on that particular matter?
What should have happened neatly was to step down that matter, take that matter on appeal, and let the appeal court decide whether there is a bias or not, whether it should sit or not. That's what should have done. That's the neatest thing that should have been done. They are accused of bias. First and foremost, step down the matter, allow the appeal the prosecutor should go on appeal on behalf of the chairman, and then let the Court of Appeal decide whether there is an element of bias or not. So that you can now adjourn jurisdiction on a neutral ground.
Is that usually what happens in a normal court? What we see happens in a normal court is that when a judge is accused of bias, the judge recuses himself. So and oftentimes, the case is transferred to another judge.
So why was it not done here?
Could it have been done? Could they have transferred that case in this matter? Because if you say that the appeal court will sit on it, what if the appeal court finds that, there was no case of bias? Couldn't that in itself introduce some bias in the matter?
No. As long as a higher court, an appeal court, has now looked into the accusation of bias and then found nothing about it, then the tribunal can now sit comfortably and then neatly. But a situation where such was not done, you just on your own, ruled out, it calls for something more.
What are your impressions?
My impression is that we need to understand clearly what is the core mandate of CCT. It is basically and primarily to intervene, adjudicate over infraction of code of conduct by public officers. Therefore, other courts, other superior courts, have their jurisdiction housed by the Constitution. That is the only tribunal, that is the only CCT we have. And frivolity of accusation of bias appears to be what was being played out in the entire process.
You call it a frivolity, but
yes.
Oftentimes there are usually strong grounds upon which a judge would say,
I'm coming back to that. Yes. Let me take this issue of motion or application for want of jurisdiction of the tribunal. The CCT has what we would call ACJA as the procedural law with which its proceedings are conducted. All applications, interlocutory applications, cannot stall proceedings. They are to be taken together and decided upon when judgment was delivered. And you heard yesterday, the court decided, the CCT decided on the application that it had no jurisdiction. There was fairness in the entire trial. We should not be sentimental about it. We should not try to confuse the members of the public who are not fully versed with what the position of the law is. In my humble view, the CCT did what was within its constitutional mandate. Mm-hmm. It gave fair trial. Mm-hmm. The immediate past Chief Justice of Nigeria was given fair trial.
No, his lawyers don't think so. That was one of their comments yesterday. They believe that the Chief Justice of Nigeria was not given a fair hearing.
That's what we expect.
And now we understand that he has, the Chief Justice, former Chief Justice, I should say, because I think he's put in his retirement now. Former Chief Justice has gone on appeal on 16 grounds. We had that immediately, shortly after, before the end of yesterday, which is, some people will say, was rather fast. The judgment was passed yesterday, and we heard immediately that he's filed an appeal, or he's filing an appeal at the Court of Appeal on 16 grounds. So in other words, it was saying that they had already been preparing this. They had already seen this coming and were prepared for any eventuality. Have you seen some of the documents, or have you seen the grounds upon which he's going on appeal? Let me ask you, Mr.
I have.
Yes.
I've read through the entire gamut of the process file containing 16 grounds.
Yes.
The first of which is challenge of the CCT jurisdiction.
Yes.
I've emphasized it over and over that the CCT is the only adjudicatory body that possesses the requisite jurisdiction to determine cases of breach of code of conduct by public officers. No other court have that jurisdiction. Check Schedule 5, Schedule 15, paragraph 18, sub paragraph 1 of the Constitution. So it has jurisdiction. But at any rate, I cannot be sitting as an appellate body. I don't have that jurisdiction. Let the appeal be ventilated. It is expected that an appeal would be filed by whoever
what I'm
has
saying
lost.
here is that was at the time of the, I mean, looking at what I'm seeing here, particulars of error says the appellant was at the time the charges were filed in January 2019 before the lower tribunal, a judicial officer was not subject to the jurisdiction of the lower tribunal.
You want me to come in?
That seems to be the problem here.
You see, there is a distinction between trial for trying you in your capacity as a judicial officer. There's a dichotomy also in trying you as a public officer. There are two distinctions. The CCT did not intervene or try him as a judicial officer. He was tried. The immediate past CJN was tried as a public officer who was expected to submit or file in is
Can you really unmarry the two? Because he is a public official. Isn't that because he is a judicial official?
You see, under the Constitution, the entire democratic governance is placed on three arms of government: executive, judiciary, legislature. These three bodies are manned by public officers, as described in the Constitution. And the public officers are expected to they are subjected to certain code of conduct embedded in the Constitution.
Agreed. My question is...
When that is breached...
My question to you is, I mean, you just said that he is... I mean, there are three arms of government.
Yes.
But the judiciary just have special rules guiding its own.
It does.
Its own conduct and
Yes.
trial of its own officers.
Yes.
So can you unmarry, you know, public officials and judicial officers in the judiciary when it comes to matters like this?
This is Section 158 of Section 1 of the Constitution. Stipulated clearly that certain statutory bodies, NJC, CCB, FJSC, INEC, Mobilization Commission, they are independent of each other and they cannot take control from any of the bodies that I've mentioned. So the CCB had its own role. NJC had its own role. CCB, by the constitutional provision, is to take complaint from members of the public or from anybody of infraction or breach of code of conduct contained in the Constitution. And where it is investigated, the Constitution has created another body, which is the adjudicatory body, that is the CCT, to try such infractions. You see, the whole essence of code of conduct is to entrench probity, transparency of our public officers, because the whole such office in trust for the public.
Well, I know you've been itching to respond.
Yes, let's take it this way. The Constitution, 308, defined a judicial officer separate from a public officer. So the Constitution was not sleeping when it carefully defined a judicial officer separate from a public officer. If you also look at section, I think section 174 or 178, where it's also called the issue of public officer is brought in under the purview of CCB, section 178 or 174. So, the fact that the Constitution under section 308 defined a judicial officer and then brought them under the section he referred 158, where the NJC takes up their matter, and if there is any issue, Senate and all the rest of them, being either a head of court of the state or of the federal or the CJN, it goes to the Senate or the House of Assembly where that is how it is paneled.
I'm afraid
The question of CCB or CCT having a jurisdiction under a sitting judge does not come in.
Okay. You will expatiate a bit more on that when we come back from this break. Please stay with us. We still have with us in the studio Mr. Chukwuma, who is a senior advocate of Nigeria and a former Attorney General from Imo State, I should say, because he could be a former Attorney General and still not be from Imo State. Well, we also have with us in the studio Mr. Tajuddin Ladoja, who is a legal practitioner, and we're looking at the grounds upon which the Code of Conduct Tribunal yesterday passed judgment, a conviction, more or less, on the former Chief Justice of Nigeria. We also understand now that the Chief Justice has filed an appeal on 16 grounds, and these are the matters that the gentlemen in the studio are examining this morning. But just before we went on break, you were making a distinction between a legal, a judicial officer and a public official.
A public officer. So, the Constitution clearly defined a judicial officer and a public officer. What the CCT has jurisdiction over is public officer. That's what the law that established it, that's what the Constitution said. Public officer. I agree that there is a small conflict that existed where in the schedule for the CCT, where is defined a public officer to include a judicial officer. Then what's the position of the law? Where the substantive law runs in conflict with a subsidiary one, as the schedule. What is the position of the law? The position of the law is, as what the Court of Appeal has said in the case of Woye, that the subsidiary law should give room to the substantive law. So, Section 308 has defined a judicial officer separate from a public officer and has given jurisdiction of CCT and CCB to that of a public officer. If, as they have done, the schedule has now included that of a judicial officer, the position is that that is wrong. It is inconsistent with the provision of the main law.
Tell us, sorry to interrupt you, but tell us what you see are the similarities between this matter and Justice Ongwuta. Because you understand that that matter came up in court yesterday, and the Code of Conduct Tribunal chairman ruled that he could reverse himself, or the court could reverse itself on the particular matter.
Thank you. That case, that particular case, was tried, decided upon on the leg of the affected judge as a judicial officer. You cannot take or arraign a judicial officer before a court of law without for offenses related to his position as a judge, like for instance, taking bribe, not delivering your judgment within the prescribed period stated in the Constitution, or not sitting on time, or any conduct unbecoming of a judicial officer. When such is the case, you will be treated as a judicial officer and be dealt with or disciplined by NJC. Where that is not done, you cannot arraign him before a court of law. So in this particular case, the Court of Appeal set aside the entire process leading to the arraignment of the affected judicial officer on the basis that he was not first and foremost taken before the NJC. The tribunal, the CCT, had to strike out a similar case brought before it relating to Justice, Lord Justice Ongwuta. But the CCT had in law to have so held, because it is when you are dealing with a public officer, you don't have to pass through the NJC before the matter is dealt with. Like the analyst said,
if the CCT erred, does it have the power then to say,
of course it has.
I erred?
Yes. And it will not follow.
On which ground?
On the ground that the
shouldn't
decision,
it be citing laws?
On the ground that his decision is wrong. Having found out that his decision is wrong, is to retrace his step in future situations, as it happened in this case. Like the last said, The Constitution defines who a judicial officer is. The same Constitution defines who a public officer is. And this includes, like he said, the Chief Justice of Nigeria, all justices of the Supreme Court, all justices, the President of the Court of Appeal, all justices of the Court of Appeal, all chief judges of various states in the Federation, they are public officers. So they are wearing two jackets. One, as a judicial officer. Secondly, as a public officer. When you are appointed as a judicial officer, you are expected to declare your asset within a particular time frame. Not only your asset.
Gentlemen, we have been told that this matter is most likely going to get up to the Supreme Court.
It will get to the Supreme Court, definitely.
You are confident of that?
I am.
Why do you think it's going to get up to
Because it is unprecedented. This is the first time a former Chief Justice of Nigeria was taken to court for breach of a code of conduct tribunal, a code of conduct as contained in the Constitution. Even without him being a Chief Justice of Nigeria, in all criminal trials, you don't stay, you don't wait, you don't rest until when you get your point ventilated up to the last court. So I am not surprised that my Lord appealed.
Yes. So the question now is, why did the tribunal say it erred in that of Nguta? Why? Why did he?
You don't
it is all because it's now taking his head because of the target. Just to reach the target.
I mean, it is a convenient answer, some people will say. But assuming it did make a genuine error, could it have reversed itself?
Of course, it cannot reverse itself.
Okay, well,
it cannot. But the most important thing, I think the first ruling on Nguta is correct. And because it is correct, and it will be very inconvenient to follow it because of the target in the one at hand, so it was now said to be error. Otherwise, that ruling is correct, and this one, it ought not to have had jurisdiction to try. Well, because he's a judicial officer who NJC only
we're going to see how this proceeds, because I know that we do not have enough time. We're totally out of time.
Can I just quickly chip this thing?
We ought to have started way earlier.
Can I quickly chip this thing?
We're out of time, sir. My sincerest apologies. We really have to go. Well, I have to thank you, gentlemen, for coming on Sunrise Daily this morning and for your patience waiting with us this morning. We still have in the studio with us, they're about to leave now, Mr. Chukwuma Machukwume, who's a senior advocate of Nigeria and a former Attorney General of Imo State. And we also had with us Mr. Tajuddin Lajada, who is a legal practitioner. Sunrise Daily will continue in a moment. Please stay with us.